states had no lawyers at bail hearings. Now only 9 do. So Texas is one of only 9 states that don't provide defendants with lawyers at their initial bail hearings. There's just been litigated a lot recently around the country. Maryland has recently emerged from 6 or 7 years of litigation about whether defendants have a right to counsel at their initial bail hearings. The defendants won that litigation, and so now the Public Defender's Office in Maryland is providing counsel to all defendants at their initial bail hearings as a result of the litigation. It went up to the state Supreme Court a couple of times. There's also, before we move on from the slide, New York, the highest court in New York, which is not called the state Supreme Court, it's called something else. The highest court in New York has held that defendants have a right to counsel at bail hearings in a decision that was issued within the last 5 or 6 years. And so New York's Indigent Defense Commission is currently issuing a large number of grants to counties to help them provide lawyers at initial hearings in order to respond to that case. And the Federal Court of Appeals of the Ninth Circuit currently has a case before it that deals with this issue of whether a bail hearing is a critical stage. So there's litigation going on in different states and federal circuits that are this issue is continuing to be litigated. One of the questions that I often get when I talk about this topic is, what would a lawyer do at a bail hearing? The judges ask me when I talk to them. And I think part of that is we're used to this being sort of the, little in and out thing that happens really fast in the jail. It doesn't really seem like there's a lot of lawyering going on, especially in places like aren't Harris County, where it's just a defendant in a back room at the jail. It's not a courtroom type setting like we have here with the prosecutor. So lawyers can help defendants develop and present information on all bail factors and facilitate individualized bail determinations as required by law. So Jay talked about what the 5 factors are that your court should be looking at when they set bail. We know based on the bail schedule that they're only looking at a couple of those, and they certainly are not looking at ability to pay or making individualized determinations. And frankly, without a defense lawyer there, it'd be hard for the court to make that individualized determination and have the information that they need to do that. Defense lawyers could play that role. And they also could prevent clients from making incriminating statements to the court in the course of arguing for bail. So a lot of defendants don't try to argue for bail. They don't know what the factors are. They don't know what they should be saying anyway. But if they try to argue for bail, there is a very high risk that in the course of talking about, well, this is really what happened, or whatever, that they're going to say something that would incriminate them in their case. And in Harris County, the DA is there to hear that, should they make an incriminating statement. Would having a defense lawyer bail really matter? What would they do? There has been one study of this in Baltimore. So Maryland, just so you know, has a system where people are brought before a magistrate in the jail for an initial bail determination, and then within 48 hours are brought before a judge who revisits bail. So they have an automatic reconsideration of bail within 48 hours. And the litigation focused on, did they have a right to counsel at that very first bail hearing, or was it okay to make them wait 48 hours? Defendants who had lawyers at that very first bail hearing were 2 times more likely to be released on their own recognizance. Because the average money bail is $500 lower. So it did make a difference. And they've also found that that initial bail hearing and not waiting 48 hours is important because that first bail setting is sticky. Judges don't like to really revisit what other judges do. So even when you have a right to go before another judge and ask for a modification of the bail setting later, judges don't really want to mess with what other judges have done. So once that first bail gets set, the defendant is very often stuck with it. And in Harris County, there are some pretty stark numbers on that. So in fiscal year 2012, there were 75,000 probable cause hearings in Harris County, so 15, 17 hearings where defendants have bail set. Trial courts lowered the bail amount that was set by the magistrate in 40 of those 75,000 cases. So that first bail setting sticks. And when you're appointed to that case and you go argue for a bail modification later, that is an uphill battle if that bail is already been set by the magistrate at a level and hearing that you are at. So I just want to finish by providing some additional resources. My office put out a report about a year ago that talks about a lot of these issues, specifically in the context of Harris County, the jail population here. And then Alex Bunnan and I had an article in Voice of the Defense earlier this laying out the legal case for a proposal for having counsel at 1517 hearings in Texas.
Mark asked me to tell y'all a little bit about some of the reform efforts that are going around to try to increase pretrial release. And since so little is going on, frankly, I didn't think a PowerPoint was really necessary. This should be quick and dirty. Is there a problem, David? Okay. So regarding local efforts, there are a few things that we thought that you should know about. Since the Public Defender's Office has opened and Alex Bunnan has been the chief, one of his goals has been to get defense representation at those bail hearings. And what are we in our third year now? So there have been ongoing conversations, let's just say that, and there has been increased interest by the judges and some county officials. So I can say this, that progress has been made and that there's more interest, and we hope it will happen soon. So I can't say much more than that, but it is an ongoing conversation, and hopefully it will be happening. There is also, you may have heard, a new director of pretrial services needs to be hired, and so a national search is underway right now. A hiring committee has been formed, and Alex from our office has been appointed to be on that committee. So there is defense representation in terms of the hiring of the new pretrial services director, and hopefully, with this new director in place, there will be good relations between that person and the judges, and there will be more trust between pretrial services and the judges, and that means, better trust in their assessments in terms of risk assessments, and hopefully that will result in more personal bonds coming out of that. At the state level, very difficult to make any traction on these issues, whether it be defense representation and magistration or any sort of reforms to the bail bond system here. Regarding defense representation and magistration, what that comes down to is if it was attempted to mandate that in any way on the counties, that would mean that the counties would have to pay more money for attorneys to be at those bail hearings. The counties already pay 85% of indigent defense expenses in this state. Counties already feel like they're paying too much, and the state is not picking up their fair end of the tab. So undoubtedly, if the state was to attempt to mandate that on the counties, there would be massive balking, and they would say, yeah, screw you, no way. I don't anticipate that the state is going to want to pick up any more indigent defense expenses. They already don't pay anything out of general revenue for indigent defense. All money right now spent on indigent defense comes out of court fees, comes out of a little bail bond fee, comes out of fees that lawyers pay in order to get licensure. So the state really doesn't pay anything right now. It comes out of defendants' pockets and lawyers' pockets, and the bail bond fee comes out of the defendants' pockets too, or their families. So I see that as a tough sell to get the legislature to pony up in order to put lawyers at the bail bonds at those hearings. And then that brings up the powerful bail bond industry itself. Over $400,000 in political contributions were made by the bail bond industry to Texas politicians between 2002 and 2011. So they've got money, they've got power. The one hearing that I saw that attempted to reform the bail bond process was in 2009. At the time, I was working for Senator Rodney Ellis as his criminal justice staffer, and the Criminal Justice Committee had a hearing on a bill called SB 498 that would have instituted partial cash bonds. And what that is basically the county, in a way, can serve as the bail bondsman, and a defendant would make a partial cash bond on, it would be, say, 10% of the total bail amount. They would pay that to the county rather than to a bondsman. And then if the person showed up for court, they could get 90% of that money back. And so it would, this was all discretionary. It would be up to the counties if they wanted to do it. There was no mandate, but it opened up this possibility. It was a possibility that some counties were already engaged in. Some question its legality. So, they just wanted to put it on the books and make it legal and make it clear to all counties to do this. Well, that didn't go over very well with the bail bondsmen. There were, I can't say if they were all bail bondsmen, but 160 people signed up in opposition to this bill. Thankfully, they all did not want to testify. It was, basically the room is probably about as big as this has the center area, and like the last 4 rows back there were just, very large men standing in the back, staring the legislators down, making it clear that this was not going to go anywhere. And that bill didn't go anywhere. It died right there in committee. They didn't even bother taking a vote because it was going to die. And so, that's what we're up against. Anybody who is interested in any sort of reform at the statewide level, so it's unlikely. So that's why it's critically important that reform happens at the local level, that you as defense counsel is arguing for lower bonds here at the county level, and hopefully we can get some real reform here in Harris County soon.
Good afternoon. I'll just take a couple of minutes. I had the privilege of serving a year as the elected attorney representative on the Harris County Bail Bond Board. I got interested in that position after seeing several of my clients get screwed by dishonest bonding companies. And serving for that year confirmed what I already believed, which is that most bondsmen, not all, but most, I would put at a level of honesty and decency at about the same level as tow truck drivers. Our job, and how this carries over to us, our job as defense attorneys, unfortunately, is to sometimes have to educate the judges about what bondsmen can and can't do. A common example are bondsmen that will surrender, try to surrender a bond. Well, the law requires that they tell us, the defense attorney, beforehand that they try to do that. The last couple of years, bonding companies have gotten better about doing that. One practice tip that I've found is that what most judges, it's not their fault, they don't deal with this a lot, but what most judges and a lot of bondsmen don't know is that the government code gives the judge, district court judge or county court judge, the authority to order the bonding company to refund the bonding premium. What's the premium? The premium is the fee, the 10%, typically the 10% that the person on bond or his family has paid. How do you use this? got a client on a $20,000 or $30,000 bond. The bonding company is starting to regret writing the bond. They don't have any real reason to surrender the bond. They'll make something up. You're notified of it. Very often, it doesn't take much to convince that bonding company, hey, Mr. Jones at AB, I'm making up a bonding company. That was not a Freudian slip. It was not. So, Mr. Jones at XYZ Bonding Company, I got your notice that you want to surrender my client's bond. That's fine. I don't think you have really grounds to do that. So we're going to ask the judge to order that you return the $3,000 on the $30,000 bond that you wrote. Very quickly, when I've had those conversations, they start to realize that they don't really have a leg to stand on, but they're not used to us, as defense attorneys, fighting for, it's hard enough to fight for our clients in court. A lot of us don't have the time to also fight against dishonest bonding companies, but I would encourage you to do that. I don't really have anything else.
Lori, on that same note, I had a case once where they said they gave you notice, it was a phone call at 8:35 in the morning. The code says they had to give us notice.
It's gotta be written, and what they've done lately is they've started faxing it over. Judges, I've found, once you educate them on what the government code allows them to do, are very receptive to working with us and our clients on these issues. So if you lay out for them, judge, you can do this, and and let's have a hearing. You're going to get a lot of bonding companies that are going to back off. Yes, sir.
Well, can they surrender the bond based on?
Well, a lot of it's contractual, Christmas. A lot of it's contractual, and so they'll say, picking up a new charge, not meeting their financial obligations, not meeting their obligations to call and keep in touch. And I've had bonding companies say, well, you guys not keeping in touch, and then my client brings me his phone logs where every Wednesday at 2 p.m. He's calling. The reason they do this, what I found, is that there's a lot of, and Kathy Braggs on here, if she was, I think she'd agree with me. There's a lot of bonding companies that are writing bonds that they really have no business writing, and then they start regretting it. And they only have, I don't know how much y'all know how this works, they only have a set number of dollars of bonds they can write. And if they've got a guy sitting there on a $30,000, $40,000, $50,000 bond, that's $50,000 that they can't write to somebody else. So the dishonest bonding companies will find any reason they can, in my experience, find any reason they can to get off that bond. It's usually some fiddly BS. And if you ask the judge to have a hearing, then the judge can let the bonding company off that bond and say, well, XYZ bonding, you've got to give these people their bonding premium back. Yes, ma'am. And this isn't just for me, I'm the dumbest one up here, so
Two things. I suspect when I'm talking, I'm gonna say it, so I'll try to get the answer away from this place. I'd like to know, since you were on the commission board, like, what bonding companies you found to be dishonest. I really don't have it. I will as a right to this problem. Until we apply it, and the conversation will not have happened. I just want you to all know. So we can talk about that later. Yes, the second question I have, for anyone on the panel, is on the rare occasions where I've asked for a bond reduction. I mean, at least for me in preparing for a bond reduction hearing, it's not real simple. I mean, I've got to talk to who they live with, I've got to try to get them to court, testify at the hearing. I've got to get them to find my bills and stuff like that. So we talked about doing it really quickly at the initial bail hearing. We're trying to do that if it's possible. But how good an argument are you going to make without having the opportunity to go and get credible witnesses? In our case, it's exclusion.
Yeah, I think what happened is the Maryland study, which I think is probably the best example of this,
on that, our hearing officers do have that information. We have a pretrial services agency, 24/7, interviewing these people. They have a full report of the hearing officers' hearing. The problem we have is that our elected county and district court judges won't let the hearing officers give PR bonds. Every one of them have a big thing of yellow stickies on their bench saying, court 3, no PR bond. Until we educate our elected judges that they should be doing this, the initial bond hearing with the probable cause hearing officer is a waste of time.
Well, I mean, you could argue for a bond reduction from the schedule, just like the prosecutors argue for upward adjustments from the bond schedule, but yes, you do have other issues with personal law policies here that require more global solutions than just having to go inside.
What,
Who's in charge of calling these? Yes, sir.
just to follow up, what can we do to change the pretrial services organization that is here existing to help do pretrial bonds, to change it back to that and away from what it is now, which is a pretrial probation fund? Because even if you can get a pretrial bond for your client, you know, they're gonna have so many conditions and so many costs, that if you've got a client, like all of my clients have no money. I represent Indian people, they can't afford $100 a month for the leg monitor, or $25 a month for the P test, and $11 for an offender's ID card, and they haven't even convicted them. How can we as a group address those issues with our elected officials? So it's the judges that are stopping, you know, this, it's just kind of a general attitude that pretrial bonds are like poison.
Yeah, I mean, just to speak to that, part of the reason why I specifically wanted this panel to be here, because I don't think that this is just a defense attorney problem, it's systemic and it's cultural to our courthouse. I really wanted the indigent defense bar to hear about exactly how screwed up our system is compared to everybody else. And they really, I think, sort of by working en masse and bringing up bond issues with more regularity than we do, you know, it's not going to be a sea change overnight, but it's a step that we can all take together.
I think the hiring of the pretrial services director is something that needs to be paid very close attention to.
What we had to do with Carol Doyle, I don't know if y'all knew Carol, but Carol tried really hard, but she got to the point where they were turning her into the head of the community supervision and corrections department instead of another pretrial services people. And I don't know, again, whoever this person's gonna be is gonna be working for our judges, and until they change their attitude, I don't think there's much of anything that can be accomplished from the perspective of the director of pretrial services. You know, they always feel under the thumb. I mean, the judges spent how many hundreds of thousands of dollars on that last study they did, that basically told them, you need to grant some more pretrial bonds. And they totally ignored it.
And I think other people are engaged in political advocacy on this issue. I mean, DOJ is engaged in this, like, CCJC is working on it, the Civil Rights Project, Rodney Ellis's office is sending letters, we're working on it. But there are all these other advocates working on it. I mean, I think that what we're here to do is to, you know, hopefully reach out to you all so that we can kind of work together on those issues and talk to you about why we think that they're important to your clients. I mean, not that you don't know that, but kind of bring this conversation that's happening in the advocacy community together with what y'all are seeing in the defense bar.
Couple more, about 3 more. Michelle, you had your hand up, Michelle back?
Pardon my ignorance, but I was just wondering, after a case is disposed of, is the defendant required, I've never had to post a bond, thank God, I don't want it, but does the defendant still have to pay whatever was agreed upon after the case is disposed?
It's a good question. The short answer to your question is, yes, contractually. Let's say the bond's $50,000 and the contract for $5,000. Most bonding companies will do a payment plan on that. That's where you hear our clients saying, well, I gotta pay you and I gotta pay the bonding company. So they're still contractually obligated. It's, unless it's been a forfeiture, I've not seen a bond, most of these people are judgment proof anyway. So I've not seen bonding companies sue over that. But it's contract.
Go ahead.
At least one court that I'm familiar with, I don't know how many other courts do this, requires as a condition not only a pretrial, personal bond, but any bond, where the defendant is accused of a DWI or, even a driving device is suspended, that this defendant, either get a blow and go device or another device. If he doesn't have a car, he's still required to have a certain blow device that he's supposed to pay, I think, $7 a day. These are prohibitively expensive. In the cases I've dealt with, these people have already been found indigent. It can result in payments of $200 a month if it's just this blow device, $7 a day. These are outsourced to companies for private profit. I don't think that's a just procedure to make these outsourced for private profit and have all these charges applied across the board. So I don't know what the solution is, but it's prohibitively difficult as a condition of bond, personal or otherwise.
Find a viable candidate for Ward 14.